to Masterclass 2. Today, let's discuss a little bit in detail about the privacy bill that is underway, the PDPB 2019. Let me take you through the scheme of the PDPB, and maybe then we will discuss a few things that make it different from the global laws, and we will discuss a few idiosyncrasies around the PDPB. You've heard about it a lot recently because Amazon refused to appear before the JPC recently, and so you know that it is a trending topic. The reason why the PDPB came into picture was to address a few issues that the existing framework did not address, which we discussed in the previous masterclass. One of the main things that it does is that it sets out what are the data privacy protection principles. It deals with all types of personal information and not only sensitive personal information. Secondly, it lays down the rights of the data principles. It also tells you how you can transfer the data from India to any other country. It also tells you what are the remedies in case there's a breach by any corporate or any person who should be governed by the data privacy bill, and if he fails to do so. It establishes the DPA and says that what are going to be the role of this data protection authority in India. It is a very important legislation, and it will definitely affect pretty much every company which is processing data on any level, right? As long as it is not a small entity, which is an exemption that is provided in the data privacy bill, but these small entities are going to be very few entities, so pretty much each and every entity will be hit by this data privacy bill, and the penalties are really huge, and so we have to be mindful about complying with the data protection bill once it does become the law. So now let me take you through the layout of the PDPB 2019. Well, it starts out by telling you to whom it is applicable. It is important for each one of us to understand who are the stakeholders in a privacy setup, right? One is the data fiduciary, who is the person who's processing the information. And processing includes anything. It even includes collection, storage, or maybe profiling data. So anything that you do with data, pretty much anything, that is processing. So the first stakeholder is the data fiduciary. The second stakeholder is the data processor, which is the person who is doing whatever he is doing with the personal data on the instructions of the data fiduciary. So these may be like any person who, take for an example, a data fiduciary hires a data processor to carry out what he wants to do with the data because he does not want to do it himself. So that is what is a data processor. And third and the most important stakeholders are you and me, the people whose data is being collected, which are referred to as data principles. Now, to whom is this legislation going to be applicable? As of now, the bill makes itself applicable to anyone who is processing the personal data of any business that is set up in India or any individual who is an Indian citizen, irrespective of whether the processing is taking place in India or outside India. So it has an extraterritorial application, just like the GDPR. Similarly, it also applies to any Indian entity that is processing data. So for example, just because an Indian entity is processing the data of a data principal who is outside India does not mean that such a data fiduciary will not have to comply with the data privacy bill. Even corporates which are processing data of foreigners will be caught within this legislation. However, if you refer to section 37, there is an exemption that has been provided which states that if a data fiduciary applies to the government, it can get an exemption of from the application of this legislation, saying that it is only processing data of data principles outside India, and it is governed by that country's legislations, and hence two legislations should not be applicable to him. So that is a very, very interesting feature which is not till now found in any other global law related to privacy. This is a thought that has come to the mind of the Indian legislators because of the experiences of the other jurisdictions. So with this, let's move on beyond application. What are the data protection principles? For example, data minimization, that you need to collect only that much data that is important. You need to only process the data for the purpose for which you have collected the data and obtained the consent of the data principal. It tells you how long you can retain the data. That is, it is supposed to be only retained for the time period for which it is useful for the corporation in respect to the purpose for which the data has been collected. It lays down these set of 7-8 principles, and then it moves on to guide you as to how you can ensure that these data principles are fulfilled. For example, it tells that each and every data fiduciary needs to submit something called privacy by design. It is a document which every corporate will have to make, wherein it will say what are the technical and organizational controls that it has put in place inside the organization to ensure that it can abide by the data principles that are set out in the data privacy legislation. And this particular document, which will have to be submitted to the Data Protection Authority, right? And it will have to be approved by them. So these are additional burdens that are put on the data fiduciaries so that the rights of the data principles are protected and they become a part of the organization's culture. Thereafter, it goes on to lay certain things that will have to be followed by something called a significant data fiduciary. There are two categories of data fiduciaries. One is data fiduciaries, which are pretty much every data fiduciary, and another is significant data fiduciaries, which are going to be regulated in a more critical way, because these will be organizations which process volumes of data much higher than a normal data fiduciary, and they process sensitive information about any individual or any social media intermediaries. What these organizations will have to do additionally is that they will have to register themselves with the authorities. You will also see that these organizations, significant data fiduciaries, will have to compulsorily undertake a data audit by external auditors. Now, these external auditors have the authority to give this significant data fiduciary a trust score. So this is going to become really important, because a higher trust score would mean that more and more consumers will trust the data fiduciary, and hence their business will increase, right? So while it does put some burdens on the data fiduciary, it will reward such data fiduciaries by more business, because there will be more trust by consumers in such data fiduciaries. Significant data fiduciaries will also have to necessarily appoint a data protection officer, which has to be an Indian employee of the company. So this is extremely important again, because there will be a person who will be specifically designated to look into the whole privacy affair of the company. So now, after sort of setting out how to ensure that the organizations comply with the privacy law, it sets out a set of rights for the data principals, such as the right to access the information that any data fiduciary has about them, how there is a right for the data fiduciaries to get any information that is wrongly collected by any organization, to have any information erased that is no longer necessary for the organization to sort of keep with themselves anymore, for data portability, so that from one organization, the data principal is able to transfer it to another data principal. And a unique thing again here, that there is a distinction that is made between the right to erasure and right to be forgotten. Generally, the GDPR says that right to erasure or right to be forgotten is one and the same. But here there's a distinction made, and we will have to see how it's going to play out, because it's a slightly complicated distinction, because right to be forgotten, it can only be exercised by the data principal by approaching the courts. It cannot just simply be exercised by approaching the data fiduciary. What is the relationship between a data processor and a data fiduciary? It tells you that there has to be a contract between the data processor and the data fiduciary, and the data processor will have to necessarily follow the instructions of a data fiduciary in processing the personal information. And that if it fails to do so, the breach, if at all there is any, will be affixed even to the data processor, even though it is merely processing the data and is not determining the means by which it is processing the data, because by not following the instructions of the data fiduciary, it somehow does determine the means by which the data is to be processed, right? So this is a very, very important aspect, because just by calling myself a data processor does not mean that I'm a data processor. I have to be a data processor in true sense by ensuring that I am merely following the instructions of a data fiduciary and not applying my mind as to how the data should be processed. Now let's move on to the next very interesting part of the data privacy bill, much debated, about whether or not the data from India can be transferred to other countries. After a serious, fight by the market, that please do not make it compulsory to store all the data that is processed in India to stay in India, because the cost of that will be so high. It said that personal information can be transferred outside India without any restrictions, as long as such information is not critical personal information. Now, critical personal information is a notch higher than sensitive personal information, right? Something that is going to be extremely important for the country and for the citizens. But it says that the regulator, once the DPA comes into picture, will have the authority to define what is the critical personal information. And as for the sensitive personal information, while it allows its transfer outside India, it does say that a copy of such information has to be necessarily kept in India. Only then it can be transferred outside. We all have a few rights, but all rights are conditional, right? And all rights are relative, because there is something that is more important than an individual's right, which is the country's sovereignty, integrity, the rights of other individuals, which are a lot more in number as against you when they come into play, the health of the nation, right? The biggest example being the pandemic. So there are certain situations that have been laid down in the data privacy bill, which states the circumstances in which the government of India can process the personal information without taking consent of the citizens, right? These rights have been given to the state when they can process personal information of individuals without the consent of the person. Interesting exception, which is a sandbox exemption. Now, what is a sandbox? It is also a unique feature of the Indian bill, which says that suppose that a particular startup or a particular company wants to come up with some technical innovation, and for that they need to collect information without the consent of individuals, etc., because they are trying to develop a product. For example, ethical hacking, right? In such cases, they can apply to the government and seek exemptions to certain provisions of the privacy bill. Of course, not in total, but certain provisions for a certain period of time. So this is more to ensure that technical innovation is not hampered by the privacy bill. The show must go on. Now, the next very important component of the data privacy bill is the setting up of the Data Protection Authority. It says that there will be 6 members who will constitute the Data Protection Authority, how they should be appointed, the period for which they should be appointed. It lays down the powers of the Data Protection Authority and its role in ensuring that data protection is implemented in India in a very effective manner. It also says that how the Data Protection Authority can hear any grievances by the data principals and also suo motu. It can move against data fiduciaries or data processors whom it thinks is in violation of the data privacy law. So it sort of lays down, it is a comprehensive guide in telling you how you can remedy a breach that has come into picture. It also lays down how to report a breach by a particular data fiduciary or a data processor. For example, I am a data fiduciary. I come to know that there was a breach that was done in my company. It makes it my immediate duty to report such a breach to the DPA. So here you can see that the harm principle comes into picture. So the breach has to, in the reasonable man's opinion, cause some harm. Now you may think that, oh my God, doesn't this really increase the financial burden on the company? Because all these processes and all of these controls that are going to come into picture will add a lot of financial burden. Because not only are there very, very few professionals who are trained in data privacy or who are currently being trained in data privacy, who are going to be expensive to hire, even the technology that is required to ensure that the data privacy is fully implemented in a company might be very expensive. The fine for any breach of this data protection legislation are significantly high. If a data fiduciary is unable to furnish the reports that it is supposed to furnish, it is not able to file the returns that it is supposed to file under the data privacy law, the penalty is rupees 10,000 per day of the breach, which can be maximum up to 25 lakh. So it's a really big amount. So 25 lakh for significant data fiduciaries and 5 lakh for non-significant data fiduciaries, other data fiduciaries. And along with that comes the reputational risk, which also must be taken into consideration because all papers will report it, channels will report it, and if the trust sort of lowers, your business can really be harmed. So it is very important to take this fine into consideration and a larger fine at play in case you fail to comply with the directions of the Data Protection Authority. So for example, if there is an issue and the Data Protection Authority tells you, you need to do this and this and this to ensure that privacy is implemented in your company and you fail to do so, then the fine is 25,000 rupees per day. It is subject to a cap of 2 crore. So the outflow is quite high. The reputational risk is also very high. So it is important to ensure that a privacy culture is cultivated in the company right from the outset instead of waiting for the data privacy bill to become law, because suddenly it will not be possible to just implement these controls in one day, right? We don't know how it is going to be in the Indian context because at least this data privacy bill does not lay down any such condition. Maybe there's an additional change that is brought about in the final bill. But as of now, we don't know how long that gestation period will be. We don't know whether that will be enough. So I think it is very important that at least the culture is started to build. People are made aware that there is such a law. Privacy bill cannot be implemented just by a few 5 people in the organization. Each and every employee of the company needs to form part of this solution. And before we close this masterclass, I just wanted to say that in the GDPR or maybe in any other global laws, the data fiduciary is called a controller. It is not called a data fiduciary. Just by calling it a data fiduciary, there is an additional burden that is put on organizations that are collecting data, which is that of trust. So it is not just this law, but an additional burden that is imposed on each of the data fiduciaries. So with this, I hope you enjoyed the masterclass. There is a lot of nuances. It will make for a great read for you guys.